Hey, good evening. This is Stephen Leskin. Welcome to my deep dive series of webinars on divorce and divorce law. I am an attorney in Portland. I've done a couple of webinars in the past, just kind of scattered around, but now I've put together a series covering all kinds of topics on divorce. Right now, we've got it scheduled to go through December. You can find a complete schedule on my website, which is www.leskinlaw.com. And there's a downloadable schedule there. The the webinar tonight is going to be recorded. It'll be up on the website in a couple of days if you want to go back and watch it again. And the future series will also be on the website. And so my intent here is to create a series of both practical and informative um, lectures on divorce law for people who are going through the process, and with the intent that uh, having more knowledge will give you better decision-making abilities and reduce stress. And I found that in my mediation practice, where I explain what's going on to people, that they seem to be able to get along better in the decision-making process because everybody's on the same page and they're not guessing about what the law is, and nobody has to worry about as much, I should say, as making a bad decision or making a decision that's outside the bounds of law, or frankly, by getting screwed. So this deep dive series is intended to provide people with that information. Tonight, we're going to tell you a little bit about myself, and then we'll get into it. The first part of the lecture tonight is about what's called civil procedure, and I'll get into that. But it's like how it's a court case travels through the court. It's how a divorce travels uh, through the beginning stages, through the discovery stages, through the negotiation stages, and then to court, and then what comes after a trial if the case goes that far. The second part of tonight's talk is going to be what I call what can the judge do, and that's an overview of the three big issues in divorce law. And I'm not going to get into every little nook and cranny. I'll just kind of give an overview of that, and there'll be future lectures, webinars that go deep dive into those issues. But this is, these are the types of decisions that the judge can do. And finally, I'll wrap up with post-trial matters like appeals and enforcement and modification. So this is a deep dive, and it's I'm trying to make this interesting, but I'm not trying to make it fun, right? I'm trying to like give people like solid information that they can use when they're going through the process. So this is just a talk, and um, I am going, I'll talk for about an hour, and we'll cover these topics, but the intent is really to give people information that they need when they're going through divorce. Uh, Despite the fact that I'm a lawyer, that's the only small print you're going to see in this whole talk tonight, is down at the bottom, and it just explains that having this information is intended to help you reduce stress, get a better sense of what's going on, help you negotiate with your spouse, help you understand things that your attorney may not be explaining to you if that's the case. You will notice that there's no place to ask questions here. I encourage people to call me at the office. I'm happy to engage with people. So if you have a question, write it down. Don't write it down. But my contact information will be on the next slide, and then it will be up at the last slide at the end. You just take a picture of it or jot down my phone number. Tell me that you were at the webinar, and I'm happy to talk with you. So if you have questions, uh, please know that I'm available to answer them, but just not right here in this setting. So a little bit about me, of course. You can't do a seminar without talking about yourself. Went to Lewis and Clark Law School. I graduated in 1992. I've been practicing law since September 1992. Been doing family law since about 2001. So I've been around a long time. I've been self-employed all of that time, running my own shop. with exception of about a year when I worked for another firm. I am the founder and creator of One Day Divorce Mediation, which is my way of doing divorce differently. And I don't want to turn this, I genuinely don't want to turn this into an infomercial. But One Day Divorce came about as a result of seeing how badly the courts deal with people in a divorce situation. And I wanted to rectify that. So One Day Divorce came about as my way of deliberately thinking through what would be a better way to do divorce. And so I put together my program, and it works really, really well. And I encourage you to look at my website if you're interested in that. Contact information is at the bottom. And again, I will welcome calls if you have questions. All right, so let's get into it. I'm calling this section civil procedure. And in law school, excuse me, in law school, you spend a year learning about the rules that govern how a court case goes through the courts, right? There's something called the Oregon Rules of Civil Procedure. There's something called the Uniform Trial Court Rules. There's something called the Supplemental Local Rules. And all of those rules dictate how a case moves through the court. And so I'm going to give you an overview now of the various stages that a case will go through. I'm not going to, nobody wants to hear the rules. That would be a waste of everybody's time. But I do want you to understand that there are various stages that a case goes through from the initiating document to the final judgment. Um, I made these names up. There's no such thing as a pleading stage, but it's just a way of explaining what happens. Sometimes there's overlap. Sometimes the stages overlap. Things go on at different times or at the same time. Uh, but the stages are just something that I've made up to help explain what's going on here. The thing to remember is that this is a really rational process. You laying out what your issues are. You're laying out the issues that are going to go before the court. You're telling the other side, these are the issues that we're going to litigate on. So everybody has notice. You exchange information. So all of the information is common, is on the table. And that's called discovery. And then you go through a negotiation stage and finally a trial stage, and then finally an appellate stage. And then after that, there's enforcement if that becomes necessary, and possibly a modification when there's a change in circumstance. So let's get into it. The first part of this process is called uh, um, the pleading stage. And then, well, this is kind of redundant. I'm just repeating myself now. Um, so we got the pleading stage, the trial stage, I misspoke, a pre-trial relief stage, and I'll get into that. Discovery stage, dispute resolution stage, trial, and then appeals. All right, now we're into it. The pleading stage. A divorce or any lawsuit starts with a document called a complaint or a petition. In divorce, you start with a petition, and the petition lays out what the petitioner could be the husband or wife, uh, wants. So if there's kids, you're going to want parenting time and custody and child support. You may want spouse support. You're going to want a division of the property, a division of the debts. The petition lays all of that out. And so it's telling the court, this is what we're going to litigate on. And it tells the other side, this is what we're going to litigate on. So the pleading stage frames the issues. In response to the petition, the other side, the respondent, files a document called a response or an answer. And that puts what the case at issues, because the answer will say, well, I agree with this, but I don't agree with that. And so if there's agreement, there's nothing to talk about at trial because you agree. If it's disputed, then you know what the issues are in the divorce. Failure to get the respondent served in time will result in a case being dismissed. You have 91 days from the date of filing to actually hand the respondent, I misspoke, I did not speak, to actually hand the respondent the summons and petition for dissolution. After the respondent receives that, the respondent has 30 days to file a response. Otherwise, they lose by default. So it's very important that both sides adhere to those timelines. Roughly after the pleading stage is something called pretrial relief. And the thing to know is that it will take about a year for a case to get to trial, particularly in Multnomah County. It just takes a long time. And so a spouse may not have the resources. There may just be disputes over the kids. One of the parties may need money to hire a lawyer, and pretrial relief gives that to the party that's asking for it, or more accurately, gives the court an opportunity to say yes or no to that. Right? So you make a motion to the court and you say, I need spousal support because I haven't worked in 20 years and I don't have any income and I don't have any savings and the spouse has moved out of the house and I don't have any money. So interim spousal support covers that period from the time that the petition is filed to the time that the case gets to a judge for a hearing. Either party can ask for pretrial relief. Pretrial relief is sometimes known as pedenti liti relief, which is a big Latin word, which I guess means interim relief, I would think. Um, and so parties may go to court and put their evidence on, and the judge will say, well, I'm going to give you so much spousal support or so much child support or so much time with the kids as a result of bringing the pedenti liti motion. The things that a person can ask for are interim spousal support, interim child support, custody, parenting time, exclusive use of the family home, return of personal property, and suit money, meaning attorney fees for to bring to support yourself during the case. Uh, Next would come discovery, and again, these aren't in any particular. There's an order to it, but there's not like okay, now we're going to do discovery. Discovery is initiated with a document called a request for production. And discovery could also include things like a deposition or a subpoena or a request for admissions. Those are all ways of getting to the truth of what you're trying to cover. Um, in Oregon law mandates that certain documents be exchanged. And that creates a situation where um, you're creating an inventory of the marital assets and liabilities and income so that the court knows what it's dividing up. Oregon law mandates that the parties exchange 3 years of tax returns, income records, financial statements, deeds to houses, certificates of titles, real estate contracts, retirement information, and statements of liability like credit card statements. A party who refuses to produce this may be subject to sanction by the court. So the point of discovery is that everybody has the same information and that nobody's surprised and that all of the assets of the marriage are discovered and known to both of the parties. Uh, After discovery has been exchanged, uh, the next stage is usually some type of dispute resolution. Uh, the parties may choose to engage in mediation. They may go through private mediation. They may go through mediation through the courts. Every county has a different mediation program. So some counties like Multnomah County, you can only mediate on issues connected to the kids. In other counties, like Washington County, you have to mediate on all of the issues in the marriage. So you could like discuss and mediate over spousal support, whereas in Multnomah County, you couldn't do that. So every county is a little bit different about what it will allow, what it will pay for somebody to mediate. Um, Mediation and dispute resolution is good, right? You want to see what you can agree to before you go to trial. Trials are risky, they're expensive, they're stressful, and even the best attorney with years of experience isn't going to be able to predict what a judge is going to do or what may come out in evidence that you're not expecting. So you want to talk to the other side and see, okay, what do we agree on? So if the question is, who's going to get the car and the debt on the car, you talk about it, maybe it's not really an issue. Maybe you both have um, the same idea that, wife is going to take the car and the debt, and the parties are going to keep their own bank accounts and on and on. So uh, the dispute resolution stage encourages parties to talk to each other after knowing the facts and after getting the facts together so that they narrowing the issues. And who knows, by the time you're done talking, you may have all of the issues resolved, and that obviates the need to go to court. So uh, talking is good, and maybe you'll get things that you didn't expect, and maybe you will find that you're in more agreement than not. On the other hand, oftentimes people they're getting divorced. They don't agree on things, and that's okay. And the fact that you're disagreeing is okay. There's nothing wrong inherently with disagreeing. Um, and that's what the courts are for. The courts are there, and the rationalized process of resolving disputes are there for those situations. If there's no agreement, or if there's only partial agreement, the parties will find themselves before a judge. Like I said at the outset, it could take 9 months to a year to get to a judge. Um, and so it can be a long haul. Well, there's really no typical um, family law case, but a trial can be anywhere from 2 hours to a week, um, if not longer in some cases. Uh, there are no jury trials in family law courts. Cases only go to the judge. Uh, both parties provide memoranda to the court so the court has some idea of what the issues are. Both parties make opening statements. The petitioner, the person who files the petition, gets to go first. They put on their evidence subject to cross-examination after they've presented their documents and witnesses, and the petitioner, him or herself, has testified. They rest, and then the respondent goes on and puts on his or her evidence and calls his or her witnesses and submits his or her documents. And then when the respondent rests, the petitioner gets another chance to rebut what the respondent has put into evidence. And that's called rebuttal. Um, and rebuttal evidence is just limited to what the respondent has put into evidence. Then parties make a closing statement, and then the judge will decide the case based on the law and based on the evidence in the record. So everything that's been admitted into record is fair game for the judge to rely on. Sometimes judges make the decision then and there, and sometimes they will issue a written decision later on. Suppose you go to trial and you don't like the outcome. Mom got custody and you thought that was completely the wrong decision. You only have one option, and that is to file an appeal with the Oregon Court of Appeals. Um, Over time, the range of issues that can be appealed has narrowed significantly, and it's become harder and harder for a case to get reversed. And so the court is looking for, clear errors of law and abuses of discretion. And those are both technical terms, but the takeaway is that they are both really very narrow um, pathways to get a case reversed. Appeals are expensive. If you spend $20,000 to get a case to trial, uh, it will cost you at least that much to take the case up on appeal. Um, I would also note that uh, regardless of whether or not there's an appeal, the parties are divorced. The parties become divorced as soon as the judge signs the general judgment of dissolution. And I had never heard of a case where somebody's like actually appealing the issue of whether or not they're divorced. Uh, as soon as somebody alleges that there are irreconcilable differences that have led to the irredeemable breakdown of the marriage, just the allegation is enough. Uh, you don't have to prove that. It's Oregon's no fault state. You don't have to prove that, and that's what that means. So that is not an appeals issue. Next, we're going to talk about what the judge can do. And I just want to reiterate that if you have questions, I'm not going to take questions now, but at the end of the webinar, I'll have my contact information, and I'm more than happy to discuss anything that I've gone over tonight with you and answer specific questions. So, please feel free to take down either my phone or my email or my website and give me a call in the next couple of days and just tell me you attended the webinar. I'll be happy to talk through your questions with you. Okay, so what can the judge do? The judge can only do what's authorized by law. And Oregon law on divorce is found at ORS, which stands for Oregon Revised Statute, Chapter 107. And even within that, the judge can only do what's in Chapter 107, but the statute is 107.105. That's the statute that covers what can be in the divorce judgment. So we started with it when we were going through the way a case makes its way through the court. We started with the petition and then we end with a judgment. I didn't really say that, but the whole point of going through the process is to finalize a general judgment of dissolution of marriage. And so start with petition and you end with the judgment. And so what the judge can put in the judgment is governed by ORS 107, 105. And generally, the three big areas are the judge can divide the assets, judge can divide the liabilities, the judge can make provisions for the children, and finally, the judge can divide the future income of the parties in the form of spousal support. So let's get into that a little bit deeper. Like I just said, I got a little bit ahead of myself. ORS 107, 105 governs what is in the judgment. If you want to find that and you want to read it, just Google quote ORS 107, 105, and that statute will come up. And you can read it. It's not a secret, and that will tell you what authority the judge has to put into the judgment. So that statute gives the court the authority to award custody to one of the parties, to order child support to be paid, to order a parenting plan be drafted that's in the best interest of the child. The statute deals with real property and how real property is divided. The other things that statute covers is, excuse me, is insurance for the kids, accounting for unpaid medical bills, and determines who gets the tax benefits that are available under federal law. The child support is um, determined by going to the Oregon Department of Justice website, and there's a child support calculator there, and you can put in your income numbers, you can put in your spouse's income numbers, and that will tell you what child support is. It's not a negotiated amount. Um, and I would just also note that under certain very limited circumstances, the judge can waive child support. It doesn't happen too often, particularly if there's an objection to that. But if the parties are in agreement, the court can waive, does have the authority to waive child support. It's important to understand what the judge's authority is. It's in the statute. Uh, what there's erroneous thinking that the judge can do anything, and that's not the true. And part of that erroneous thinking is on the part of some judges. And the thinking stems from this notion that divorce court is a court of equity, and there's a statute that says it's a court of equity. And this is really in the weeds, and um, this is like deep dive stuff, and maybe it's a little too deep. But a lot of times judges think, well, it's a court of equity, I can do whatever I want. And that's not what that means. The statutes give the judges authority to act, and that authority is delegated to the judges by the legislature. The fact that it's a court of equity only means that the judge has the option of imposing non-monetary awards. So, for example, the judge can make a decision about custody or impose a parenting plan or make a decision about the tax benefits or how the property is going to be divided. All of those are equitable decisions. That's what the court of equity means. So, for example, this comes up sometimes. A judge may say, um, a spouse may say, I intend to move across country. I'm going to move to Illinois, and there's kids, and the judge will say, no, you can't move to Illinois. Um, that is not correct. The judge can say, I'm going to order a parenting plan, and the parenting plan provides for parenting time in Oregon. And if you want to see your child, you have to come back to Oregon. But the judge can't order a parent not to move. Like that's one example of like just judicial overreach with the rationalization that it's a court of equity and therefore they can do what they want. The judge can only authorize the judge is only authorized to act by what authority is given by the legislature, and preventing somebody from moving is not found in 107, 105, or any of that, or any of the 107 chapter. A little bit like weedy and nerdy stuff, but it's kind of crucially important that everybody knows like what the limit of the judge's authority is. All right, so getting into practical stuff. Let me just do something here. All right. Oops. All right. There we go. I needed to move something. So division of assets and liabilities, the core of any marriage, right? People are there in divorce court and they need to divide the equity in the house or the retirement accounts or the savings accounts, or the couple has run up significant debt. How does the court divide that? So, like I said, the authority to make that division is in 107, 105. And the language that authorizes the court to make that kind of division is, excuse me, is in a manner which is just and proper in all the stances. And so the general rule, and if you speak to most attorneys, they'll say, well, in a long marriage, the court's going to divide it equitably, meaning evenly. In a short marriage, the court's going to put the parties or try to put the parties back into the position they were before the marriage. A short marriage would be 2 or 3 years. Long marriage would be 6, 7, 8 years and longer. That middle ground is kind of a free for all. Is honestly, it's kind of a free for all. It's kind of what whatever feels right will work. Um, but the real answer, the better answer, is that the intent of the parties govern. So, uh, um, two people who are older and have had lives, and they get married, and they throw all of their um, savings into one account. They don't have joint accounts. They liquidate a home and move into a home together, and all the money goes into the home, right? Or they buy a home together and they put all of the equity from their home, separate homes, into one home. Um, that's going to be a situation where the court's going to split the parties evenly because that was their intent, as opposed to two parties who are older who don't create joint accounts, right? They each have separate accounts. They file their taxes separately. They each maintain, one of the parties maintains the house and doesn't put the other on the deed. The court's going to keep those. The court's going to honor that lack of commingling, right? The intent was to keep our financial life separate, regardless of what our emotional life was like. The financial life we intended to keep separate, and so the general perception that the long marriage it's going to be split equally isn't really 100% true. The court's going to look at what the intent of the parties was financially during the marriage, and it will be the same questions with the debt. The interesting thing about debt is that there's a separate statute that deals with debt, but it's in the marriage section of the Oregon law, not in the divorce section. And the actual chapter that deals with division of the property is actually silent on how the debt is divided. But usually the same rules are going to apply. In a long marriage where things are commingled, both parties are going to come away with an equal amount of debt. If the parties did not commingle, then they'll each walk away with their own debt. And I'm going to make a comment about whether that's fair or not, but that's just the way it is. That's the way the courts will look at it. Um, let's talk about future income and spousal support. So, uh, the court is authorized by ORS 107, 105 to award spousal support. And spousal support is given for one of three reasons. One is for maintenance, and the typical maintenance award is, you know, usually typically, I don't like to engage in stereotypes, but or generalities, but typically, mom stayed at home, raised the kids, didn't work. She doesn't have skills to go out and into the world. Well, if there's sufficient money there, the court's not going to kick that person out without any resources, and that is called maintenance support. And so the spouse would have to come into court and say, "I don't have any resources. I haven't worked." Um, and I need support, and the court will award maintenance support for that. The second type of support is transitional support. So, for example, somebody's been out of the workforce for years, and their skills are lagging, and their education is behind, and they're not earning their potential. The court may award income over time or in a lump sum to help a person get back on their feet and earn a living wage. And that's the purpose of transitional support. The last type of support is compensatory support. And that's where, the typical situation is husband stayed at home while wife went to medical school. Now medical school is over and wife is making a lot of money and divorces husband. Law says husband's bought into her career and her future income. And he's entitled to that for the sacrifices that he made to help her with her career. So that's called compensatory support. And that's also found in that statute, 107, 105. Now we'll talk about post-trial. And we talked about appeals a little earlier. I would just reiterate that winning an appeal has become particularly difficult because of the narrow range of arguments that the court is willing to entertain. The court is looking for legal error or an abuse of discretion by the judge. And abuse of discretion comes about when we talked about the division of property being just and proper. That means that the judge is using his discretion or her discretion. And so if something is like way outside the bounds of what would typically be given, that's an abuse of discretion. Or the appeals court is looking for something called legal error. And that's that the standard was wrongly applied. Um, so you don't see, for the amount of cases that are out there, you just don't see that many appeals cases in family law, maybe one a month to a month at the outside. And then I would also just point out that if parties agree to a judgment, the judgment is stipulated. They didn't go to court, but they were able to agree to everything, so they stipulate to the judgment. A stipulated judgment is not appealable. And finally, the success of an appeal is dependent on what evidence is in the record. So you can't appeal something that's not in the record and something that's a legal error that the trial judge is making without filing an objection. So in order to win, you have to have the proper evidence in the file, and you have to have the correct objection to alert the appeals court that I misspoke, to alert the trial court what the error was so that the trial court can correct it before it goes up to the Court of Appeals. Very difficult to win a appeals case. The second of the three post-trial matters that I'll discuss is modification. So there's a judgment, and maybe the judgment is stipulated, the parties agreed to it, or maybe the court, after a trial, handed down the judgment, and some time has gone by and there's been a change of circumstance. Either the parties can go back and ask the court to modify the judgment. The exception to that is property. So if the court gave, 55% of the equity in the house to husband, wife can appeal that, but she can't come back and modify that. So anything connected to a property allocation is not appealable. It's a non-appealable issue. On the other hand, issues like spousal support, custody, child support, parenting time are all appealable issues. In order to get to court on all of those except parenting time, the person bringing the motion to modify has to show that there's been a significant change of circumstance. So, for example, um, husband's obligated to pay wife $1,500 a month for 10 years for spousal support, but husband gets cancer and is no longer able to work, and he loses his income and he's relying on Social Security. Clearly, the court's going to um, modify a judgment like that if it's not possible for the husband to continue making that obligation. Um, Another common grounds for modification is marriage, where there's spousal support. Remarriage of a spouse generally will cut off um, as grounds for coming back and asking the court to modify a spousal support award, if not outright terminated. And that's considered a significant change of circumstance that will lead to a change of termination of spousal support. The same for custody. Custody, you can come to court and say, well, circumstances have changed, and um, husband had custody, father had custody, and now mom comes and says, father is hooked up with, a woman 30 years younger, and he's dressing weird, and he bought a fast car, and he's drinking a lot. And I'm being a little facetious, but, father's no longer the good father that he was, and I should now have custody. Mom should now have custody. So you have to show two things for that. One is that there's been an actual change of circumstance, and that the change that you are requesting is in the child's best interest, right? So you still have to come to court and say, there's been a change, and what I'm asking for is to the child's benefit. Uh, if you're coming to court to modify a parenting plan, you don't have to show the same change of circumstance. It's only that the change that you're proposing is now in the child's best interest. And that's usually a little bit easier to modify. Kids grow older, uh, um, and as kids get older, parenting plans get out of date. It's almost accepted that at some point a parenting plan will be modified if the parties aren't really getting along, and they still need to rely on a parenting plan. I'll do a deep dive on children, including custody and child support and parenting time in a future webinar. And the last issue I'll talk about is enforcement. So you've gone through trial, or you've had an agreement to um, create the judgment. You got the general judgment of dissolution, and let's go back and say ex-wife is not paying her spouse support. She's obligated to pay, $500 a month for 3 years to the ex-husband, and she doesn't. What are her options? Um, she can file a motion to enforce a judgment. That's what's called motion to enforce, and she can do that on her own. You can download the forms through the state websites, the county websites. The Oregon Judicial Department has forms that you can download and fill out and file. And that's usually something like the spousal support is usually pretty straightforward. Uh, husband's not going to be able to produce receipts or cancel checks showing that he's paid. So it's usually a pretty straightforward um, matter to get before the court, and the courts sometimes will have an expedited procedure for that. There's certainly an expedited procedure to enforce a parenting plan, but sometimes the courts will handle the enforcement of spouse support and child support on an expedited basis. The issue, though, is what the court can do. So on the first time that the court deals with like non-payment of support, the court's just going to say, you got to do it, look and say, you got to do it. But after that, the parent has an option to bring something called a motion for contempt. And then that gives the court a full range of financial penalties and maybe even jail time in certain cases to enforce an order to pay a spousal support, or to live up to some other part of the parenting plan. Sometimes, a parent will not live up to their obligations under a parenting plan. I know that there are a lot of, particularly women, who uh, uh, their spouse doesn't take the child and they're with the kids 24/7, 7 days a week. And it's just a huge, huge emotional, financial burden on them. And enforcing the parenting plan, requiring the dad to take the child sometimes it's just necessary. Maybe there's other dynamics there, whatever. But you go to court to enforce that, or more typically, one of the parents is withholding a child, and then you go to enforce the parenting plan in those circumstances too. But the you can hire a lawyer to do that. That's certainly a part of my practice. Or you can download the forms to do that. The courts have um, Family Law Resources Center, Family Law Resources Centers, and they'll talk to you. They'll kind of walk you through a little bit. They won't give you legal advice, but they'll kind of tell you these are the forms. This is what you do. This is how you get before the court, and that's an option when one of the parties is not living up to their end of the bargain and not honoring the terms of the judgment. All right, so that brings us to an end. It's about 8:40 now. Um, please feel free, please, my contact information is now up on the screen. Please feel free to give me a call. Like I said at the outset, I'm happy to discuss issues with you. I just don't want to take questions during the webinar, but I am happy to go through and answer questions later. You shoot me an email, visit my website, give me a call, and I'll be happy to discuss any part of this tonight. If you want to shoot me an email, let me know that this was beneficial to you. I would love to hear that. I'd love the feedback and the comments. And so the next webinar is on March 6th. And so we will see you then. Thanks.